Officer Day, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor. Good morning. We are on the record calling file number 20164-660, Grosbeck RX versus City of Detroit. Date and time for what appears to be our initial pretrial, your respective appearances.
Good morning, Your Honor. Tricia Nelson, P68707, appearing on behalf of the plaintiff.
Good morning, Your Honor. Laura Sheehan, P83327, appearing on behalf of the defendant, Save Detroit.
All right. Have we made the 302 disclosures?
Your Honor, plaintiff has sent them just within the last few days, but I have not received them from defendant yet.
Ms. Sheehan?
So we've sent them, but we haven't received anything from the plaintiff either. So
when did you send yours? How long ago?
Ours were sent yesterday.
Okay. You guys, each of you, do not send me the disclosure. You may, however, send me a proof of service of the disclosure. And if you haven't gotten the other side's disclosure by the middle of next week, there's this wonderful invention that allows you to reach out and converse with people who are at a distance. It's called a telephone. Okay?
Thank you, Your Honor.
So it seems like there's really nothing else we can accomplish at this point.
Actually, Your Honor, I do have a matter of housekeeping. I filed a motion to substitute attorney within firm from Yvonne Bradley to myself, but I don't see it on the docket. And all I really have back from the court is, it looks like a fax notification of receipt. So I just want to make sure the court received it and if possible to get it entered today.
They may have it downstairs. It has not made its way to the file.
Okay.
It is in today's mail. I will enter it today. Otherwise, I'll enter it when it comes in.
Thank you, Your Honor.
Okay. Anything else we cannot accomplish today?
Not from plaintiff, thank you.
Okay. Let's get our next date then. March 19, March 19. Does that work for both of you?
Yes, Your Honor.
Ms. Nelson?
Just a second. Yep, that works for me as well. Thank you.
Okay. Then it's going to be March 19th at 10 o'clock. Anything else?
Not from plaintiff, thank you.
Okay, then what we're going to do then is we're going to close the record and we will send out to both of you a notice of our next meeting, March 19th at 10 o'clock. And in the meantime, you're going to send to me proofs of service of the disclosures. I don't need the disclosures themselves. And if you don't have the other sides by next Wednesday or Thursday, pick up the telephone and let's get this done.
Okay.
Thank you both for coming in. Have a good weekend.
Thank you, you
Your
too.
Honor.
All right, this is case number 2015258. The file is entitled Jefferson Capital System versus Tristan Smart. This appears to be our initial pretrial. Your respective appearances.
Good morning, Your Honor. For the plaintiff attorney, Ashley Nonis, P77029.
And what is your name, sir?
Good morning, Your Honor. My name is Tristan Smart.
Is it your intention to represent yourself in this matter?
Yes, it is, sir.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind that lawyer will bind you. Do you understand that?
I do, sir.
Where are we on this file, people?
Well, Your Honor, we're ready to move forward with the motion for summary.
Have y'all had any conversations about resolution?
We haven't. It's gone a little bit of back and forth since the date of filing the complaint. The defendant alleged fraud. We did a little bit of investigation on our own because he failed to fill out the fraud packet, and we do not believe it to be fraudulent. So we would move forward with the motion.
Well, let's see if there's going to be any discovery before we get to there. Mr. Smart, are you intending to do any discovery in this matter?
Yes, I am, sir. I have evidence from DT themselves.
Okay, then let's stop right here because we're not going to try the case today.
Okay.
What I will do then is I will open written discovery in this matter, and I'll send out an order to that effect. And I'll give you a return date. Your return date will be Friday, March 19th at 10 o'clock. Does that work for everybody?
Yeah, that'd be fine.
Yes, sir.
Okay.
Yes, sir. That's fine.
Written discovery is open. March 19th, 2021 at 10 o'clock will be our next pretrial. Is there anything else we can accomplish today?
No, Your Honor, all set.
Anything for you, sir?
No, Your Honor. I'm all set.
Okay, then we'll send this out to you today. And let's get started on our discovery. Thank you both for coming in. We are off the record in your file.
Have a great weekend.
Be safe. All right. This is case number 1916870, Discover Bank versus Mary Moore. This is the much adjourned motion for summary disposition filed on behalf of plaintiff Discover Bank. Could I have your respective appearances?
Yes, good morning, Your Honor. Attorney Jason Brainer on behalf of the plaintiff Discover Bank.
You remember the State Bar of Michigan?
Yes, I am, Your Honor.
Do you have a P number?
P69653.
Try that one more time.
Sure. P69653.
Thank you. Your appearance, sir.
Yes, and good morning, Your Honor. Attorney Daniel Suida, SWEDA, P number 46591, Your Honor.
All right. Now, looking at the file, it appears that at some point in time, I thought you guys were going to arbitrate the file, and then for whatever reason, you elected not to do so. The court, as I recall, in reviewing the file, had entered a 60-day stay for that to happen. It did not happen. So we're now at our motion for summary disposition. Mr. Brainer.
That is correct, Your Honor. And as you point out, Your Honor, today is the date and time. Plaintiff's motion for summary disposition. And that said, Your Honor, we would rest on our motion and note that at this time, there is no genuine issue of material fact. The defense has not raised any type of meritorious defense in this matter. And we would note that judgment would be appropriate in this matter under either C9 or C10. And again, we rest on our motion.
Mr. Sweeto.
Yes, Your Honor. With all due respect to brother counsel, plaintiff's counsel, the response to the plaintiff's motion under MCR 2.116 C9 and C10 is as follows: that the plaintiff has a valid defense against the plaintiff's claim for MCR
Excuse me.
2.16 C9.
Mr. Sweeter, I think you mean the defendant has a valid defense against the plaintiff's client.
Yes, Your Honor, sorry.
Your fault, sir.
Yes, but the defendant's position is that the complaint filed by the plaintiff is a complaint for breach of contract, that the attachments, that there is no actual signed contract between the parties that was attached to the complaint, Your Honor. There is, however, a several-page card member agreement that was attached. It's just a very generic form, Your Honor, and that the only count in the complaint for the, looks like the original complaint filed by plaintiff was on or about August 1st, 2019. It could be a different date, Your Honor. It's kind of hard to read the timestamp, but I think it was August 1st, has this is just for a breach of contract. And again, with all due respect, that the card member agreement is not a valid contract. That's the defendant's position. And additionally, too, as regards to MCR 2.116 C10, the defendant's position is that there is a genuine issue of fact regarding the amount that is claimed to be owing. There's approximately, believe the allegation is for $10,917.04. There is a statement, an affidavit that is filed with the complaint, but that's just with all due respect to it, Your Honor, it's just a conclusory affidavit that the records were checked and by that individual, and they say, well, you know, that's what it says. There's not a verified accounting of the alleged debt amount, Your Honor.
All right, I had a chance to review the pleadings here today. Mr. Sweeter, I did not see an affidavit in support of your answer. Did I miss it?
Unfortunately, Your Honor, I was not able to obtain one from my defendant, from my client, pardon me.
Is there anything else you want to tell the court, sir?
No, Your Honor, that's essentially defendant's response in a nutshell.
Let me hear from Mr. Brady.
Thank you, Your Honor. Respectfully, I'd point out that in response to defense counsel's first point that there's no signed contract, Your Honor, I would direct your attention to our brief and the Credigy case in there, and that courts have held that in the case of a credit card account such as this, where you have a contractual claim, there doesn't have to be a signed contract. Using the credit card itself constitutes agreement to the terms and conditions as laid out, we attached in our original complaint. And again, Your Honor, to the second point that defense counsel has made here, defense counsel has not attached any type of affidavit to support that there's a dispute to the amount owed, where its plaintiff has done so. We have a sworn affidavit by someone who's familiar with the accounts on behalf of plaintiff and has outlined what the balance is due and owing and would have knowledge of.
All right, the court is prepared to rule in this matter. I am making my decision based on MCR 2.116 C10 because I do not believe it is necessary to make a decision in relationship to the C9 allegations. The problem that I have, Mr. Sweeter, with your response is that the court rule MCR 2.116 G4 is pretty specific here in terms of what must be done to meet a C10 motion. Reading from G4, a motion under subrule C10 must specifically identify the issues as to which the moving party believes that there is no genuine issue as to any material fact. When a motion under subrule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his or her pleading, but must, by affidavit or as otherwise provided in this rule, set forth specific facts showing that there's a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. In the case of Barr, the complaint in this matter was supported by an affidavit, which is part of what we can consider in the C10 motion, of one Jennifer Plagman. And in essence, what Ms. Playman says is that she's has some personal knowledge in this matter, and as litigation support coordinator for the plaintiff, has information concerning the discovery card accounts, and then goes on to state that there's an account with the plaintiff and the defendant, and that there's the outstanding balance alleged in the complaint. Mr. Sweeter was unable to obtain an affidavit from his client. The court rule is very specific. You may not rely upon your pleadings. You've got to have an affidavit to meet an affidavit. So the court is going to find there is no genuine issue of material fact in this matter. I'm going to grant summary disposition under MCR 2.116C10 in favor of plaintiff Discover Bank and against defendant. Anyone who is aggrieved by my decision, of course, has 21 days to enter a claim of appeal, or perfect a claim of appeal, I should say, in the Wayne County Circuit Court. Mr. Brainerd, I think that the most expeditious way of having this would be for you to send out a proposed judgment under the 7-day rule. You obviously have to serve Mr. Sweeter with that. He has an
Certainly.
opportunity to object, but that's the court's decision in this matter. There's no affidavit on behalf of the defendant to create the genuine issue of material fact in the face of the affidavit on behalf of the plaintiff, which was a part of the complaint. Thank you, gentlemen. Look forward
Thank you,
to
Your
your
Honor.
and be safe. Have a great day.
Yes. have a
Thank
good
you too,
weekend,
Your Honor.
Thank you, gentlemen. We are off the record.
All right, take care.
Be safe.
You too.
Ms. Cowles, why are you here today?
Good morning, Your Honor. I'm here for the lab specialist, case ending at 979.
You see Detroit?
Correct.
I think I have the other side. Just Echoberry. Let me check and see, okay?
Thank you, Your Honor.
Let's admit everybody have a free-for-all.
Why not? It's Friday.
I got like 10 guys, lawyers waiting. Let's admit everybody. All right. All right. Good morning.
Morning, Your Honor.
Morning.
Who has a settled case?
I do, Your Honor.
Who said I do?
Jeff Gould,
What's your file, Mr. Gould?
spine specialist for City of Detroit, case number 20-158-552-GC.
Okay. And is Ms. Oulette coming?
I just sent her an email, but I do not see her in the Zoom lobby right now.
Okay, let's give it a couple of minutes
Will do.
and we'll see. All right. So we'll put you in the waiting room.
Will do, sir.
All right. Why don't the rest of you slackers have settled cases? I got Ms. Oulette here, so I'm going to send all of the rest of you to my waiting room while I do this settled case. So why don't you go ahead and settle some cases?
Hey, Your Honor.
Now I have Mr. Gould and Ms. Oulette. I think I have a pair here.
Yes.
This is 20158-552, Spine Specialist versus C Detroit. Date and time for pretrial, your respective appearances.
Jeff Gould, P number 83622, spine specialist on behalf of Spine Specialists of Michigan.
Good morning, Your Honor. Teresa Oulette, P72765, appearing on behalf of defendant, City of Detroit.
I understand you guys have settled your case.
We have, Your Honor.
Yes, Your Honor.
What I will do, I will dismiss your file without prejudice, and you will send me your closing documents when you get around to it. Before you go any further, Ms. Oulette, you owe me an order on another file. Take your pencil out.
We sent another one in.
I don't have it.
You don't have it?
I talked to you more than a week ago on this.
Yeah. Yeah, no, I instructed my secretary to refile it.
She didn't file an order in the first place, so she could not refile it. That was the problem. She sent the stipulation without an order.
Okay. I'll do it personally myself
Let me
today.
give you the case number.
Go ahead.
20146
Mhm.
513.
Okay.
Okay. Then
Okay.
you guys, I'll send you out an order.
All right.
Thank
Thank you,
you.
Your Honor.
All right. Thank you for coming in. We
Have a
are
good
off
weekend.
the record, and be safe, please.
Thank you.
Yes, thank you.
They were.
I had your opponent and she went away.
She just disappeared. I wonder if she had another meeting.
I don't know, but she's not here. So I guess you go back to the waiting room.
Thank you, Your Honor.
I just had her. Ms. Brzezinski, what brings
Yes,
you
sir.
here today?
I'm here on the Leanne Harris case.
And your other side is Eckleberry?
It is, and then there's actually another defense attorney, Your Honor, from Pearson and Associates.
And who's that?
On the caption, it's listed as either a Donna Pearson or a Natalie Jaboro.
I don't have either one of those. I've just got Mr. Eckleberry. So let's do this. Let's get Eckleberry and then we'll see if we have anybody on the, this is a 932?
No, this was, yes, 932, sorry.
Okay, let's see if we get anybody else on that. Let's admit Eckleberry.
Thank you.
Mr. Eckleberry?
Good morning, Your Honor.
Morning. You're here on the Leanne Harris matter?
Correct.
And counsel indicates that she thinks there's another attorney.
There should be, yes, Your Honor. Let me pull that name for you.
My options are Joseph Falzon, Mary Beth Cobbs, Leo Januszewski, and Sean Betterwood, who's on another case number. So he's just clearly not him. Does that either any of those names make sense to you?
I can tell you that Joe Falzon would not make sense because he is from my office.
Right. And Mary Beth Cobbs is from the city of Detroit.
Well,
let's see if this Mr. Januszewski is the person. No, I got him on another file. I got him on Dana Wethington versus Leon versus Westfield. Okay, here's what I can do. I can put you guys back in the waiting room. And it looks like I've got a pair with Falzon and Januszewski. We'll see about your third lawyer at some point, hopefully soon. Back to the waiting room with you both.
Thank you, Your Honor.
thank
All right, I think I have a pair. You guys are here on the Dana Wethington versus Westfield matter.
That's correct, Your Honor.
Yes, Your Honor.
All right, let's call your file. We are on the record calling file number 2016470, Dana Wethington versus Westfield Insurance. Your respective appearance.
Joseph Falls on behalf of the plaintiff, Your Honor, P80521.
Leo Januszewski on behalf of the defendant, Your Honor, P number 44631.
All right, my first question is I have some requests for admissions filed on behalf of defendant Westfield. Was this done by stipulation of the parties?
It was not, Your Honor.
No, and that's, I was going to ask Your Honor if we could get a discovery order. It was sent as being par for the course, and it should not have been. I should have sought a discovery order first.
Well, here's the thing. Have you guys done the 302 disclosures?
Yes, Your Honor.
Yes, Your Honor.
You both done those?
Yes.
Yes.
Send me proof of service. I don't want the documents, just that you serve the other side with that.
Very good, Your Honor.
Now, the reason I made the 302 disclosures is that my experience has been that in most cases, that's going to be enough to get the discovery pretty much done in these cases. Why would you need additional written discovery, Mr. Januszewski?
Well, specifically the plaintiff's deposition, he has a variety of pre-existing conditions, a former workers' comp accident and claim. And these things obviously matter to compare his pre-accident health versus his post-accident health. That's
When was the date of our accident?
let me find the plaintiff's complaint here.
The date of accident, Your Honor, is October 2nd, 2019.
Yeah.
When are these other accidents or injuries or comp claims?
Let's see. According to my records from the claims file, there was some sort of workers' comp accident on August 26th of 2019, which was a little bit before this accident.
Less than 2 months. Okay, let's stop right here. Here's what we're going to do. Mr. Januszewski is going to send me an order striking his first request for admissions. The court will permit the deposition of the underlying injured party. What's his name?
Mr. Dana Wethington.
Dana Wethington, who's the plaintiff.
Yes, sir.
All right. Let's get that accomplished in the next 30 days. We'll give you a return date.
Your Honor,
Yes,
I don't often interrupt, and I apologize.
sorry.
Can we have 60 days? And the only reason I asked for 60 days is because on March 11th, my wife is being induced,
Oh, okay.
and it's not that you need to know, it's our first child, and I've taken 2 weeks to work to be at home with her.
Well, it's important to have life balance perspective. So let's do March 11th, the child is coming?
If not sooner, but March 11th is the drop.
It's outside. Then how about April the 2nd? Does that day work for everybody?
I will make it work, Your Honor.
How about you, Mr. Januszewski?
You're saying plaintiff's step to be done by April 2nd, Your Honor?
Yes.
Yes, that's fine.
And your order striking the request for admissions?
Yes, sir. I'll put them both in the order.
Yeah, that'd be great. Anything else, gentlemen?
No, thank you, Your Honor.
May I ask a question, Your Honor?
Sure.
Would I be allowed to have the plaintiff sign authorization forms so I can get records?
That's not going to be a problem, is it, counsel?
No, sir.
Bring them to the deposition.
Okay, I will do that.
And Leo, if we do the deposition by Zoom, please just email them to me and I will get them to my client. He's very good at responding and getting things back to me.
Sounds wonderful.
All right. April 2nd at 11 a.m. will be our next pretrial date. And plaintiff to be deposed prior to pretrial. Order to strike. Defendant's first set of requests for admissions.
Your Honor, did you say the next pretrial is April 2nd at 9 a.m.?
11 a.m.
11 a.m., forgive me.
Are we good, gentlemen?
Yes, sir.
I believe
All right,
so.
sir. Let's get the orders in and you have a happy, healthy child.
Thank you, sir.
Thank you for coming in. We're off the record. Let's
Thank
get
you,
the
Your
file rolling, gentlemen.
Thank you, Your Honor.
Thank you, Your Honor.
Okay,
Good morning, Your Honor.
good morning.
How are you? Sorry, I think we got disconnected earlier.
I think he walked away from you here.
No, I was there.
Yeah,
and
yeah.
then it-
Okay, you're here on lab specialist versus City of Detroit, correct?
Correct, Your Honor.
And Ms. Cobbs is here on that.
Correct, Your
Correct.
Honor.
And you other folks are not yet a pair. Is that correct?
Correct, Your Honor.
Okay, so then I'm sending 3 people, Brzezinski, Eccleberry, Bedouin, back to the waiting room. And we'll do the next pretrial, then we'll try it again. Okay, I think I have a pair. This is 2-1-141-979, laboratory specialist versus City of Detroit. This appears to be our initial pretrial. Your respective appearances.
Good morning, Your Honor. Jessica Scheib, P number 81798 on behalf of Laboratory Specialists.
Good morning, Your Honor. Mary Beth Cobbs, P40080, standing in for the Attorney of Record Calvert Bailey on behalf of the City of Detroit.
Okay, this is our first pretrial. And my first question is whether or not the 302 disclosures have been made.
Your Honor, on behalf of the city, not yet.
Not yet. Why is
Not
that?
yet, Your Honor.
I'm looking at an order that said this was supposed to be done within 21 days of January 21st. And that deadline's passed. So this is what we're going to do since we have not done that. I'm going to order the disclosures to be made before our next pretrial. I don't want the disclosures, but I want proof of service of the disclosures sent to the court. And I will tell you, if these disclosures have not been made the next time, there will be a default or a dismissal. This is not optional.
Understood, Your Honor.
Yes,
So,
Your Honor.
March 19 at 11 work for both of you?
Yes, Your Honor. For
Yes,
me,
Your Honor, it
I'm
will.
sorry. I didn't mean to answer for Ms. Cobb.
It will work for the defense, Your Honor.
All right. And let's get this done, folks. Let's get our discovery rolling. We can't get things done until you guys do your jobs.
Understood, Your Honor.
March 19th at 11 o'clock, we'll do it again. And make sure you send to me proofs of service of the disclosures. I don't need the disclosures. I just need to make sure they've been done. Anything else we can accomplish today?
No, thank you, Your Honor.
Anything
Nothing
else
from
we
the
can
defense, Your
accomplish?
Honor.
Okay, well, thank you both for coming in and be safe.
Have
You
a
as
good
well.
day. Thank you.
You're
Thank
off
you.
the record.
Bye.
Oh, somebody showed up. All right.
I am so sorry. This did not make it onto my calendar. I don't know what happened.
All right, you are here. Which file, ma'am?
Leon Harris.
Okay, and who else is here on Leon Harris?
Lauren
Your Honor.
Brzezinski, Your Honor.
And Mr. Eckleberry, Your Honor.
So everybody except Mr. Bedouin, who's back to the waiting room by himself. Sorry, I don't have a match for you yet.
Wow.
Waiting room you go.
Thank you.
All right. Leon Harris file. We are on the record. This is case number 20166-932. Leanne Harris versus Nationwide Mutual Fire. And we have Intergon National Insurance. Your respective appearances.
Good morning, Your Honor. James Eckleberry appearing on behalf of plaintiff Leanne Harris, P78222.
Morning, Your Honor. Lauren Brzezinski on behalf of defendant Nationwide, P75259.
Good morning, Your Honor. Natalie Jabor on behalf of defendant Intigon, P78307.
Okay. First of all, have we made our 302 disclosures?
Yes, Your Honor.
Yes, ma'am.
Okay, that everybody send me proof of service of that. Okay, not the disclosure, just that you served the other side. I don't need to see all that else. Now, I take it none of you have had time to digest that material from the other side, or have you?
Not quite, Your Honor.
Okay.
Your Honor, just to give you some context for this case, my client was working at the time of the accident. She was a gas station clerk, and a motor vehicle drove into the gas station. So this action is for what is not covered by her workers' compensation claim. There is, on top of that wrinkle, a priority dispute, which may be easier to resolve given the recent disorders relative to the No Fault Act changes. But candidly, sister councils and I have not had an opportunity to address that issue.
Okay. Then I have another problem. I have some notices of I have a notice, excuse me, of deposition, together with the request for admissions. Were these things done by stipulation of the parties?
No stipulation has been entered with the court, Your Honor.
Right, it looks like my office noticed the deposition from March 31st.
And it looks like you sent out requests for admission.
Correct.
Okay, here's what's going to happen. You are going to send me an order striking both your request for admissions and the notice of deposition of the plaintiff. Now, Mr. Eckleberry, is your client the workers' compensation aspect of our case? Is your office handling that as well, or is that another office?
That is a different office, Your Honor.
Okay. All right, then let's get ourselves procedurally in place. I'll look forward for your orders, Ms. Jabaro, and we'll give you guys another date. And by the time we're together, I hope that we will have had an opportunity to review each other's disclosures and have some more conversation on where the file is. Because, I mean, everything's being picked up by workers' comp. What are we arguing about?
Right.
Well, there will be, your point is well taken, Your Honor. There are some things, obviously, that I'm sure you're aware of covered by PIP that is not covered by comp.
Yeah, but you know, the wages are going to be picked up. Obviously, PIP is going to pick up household services. Medical is going to be picked up by comp. I mean, let's find out what it is we're arguing about. Because, you know, this may just be a tempest in the teapot. We may not really have anything to really argue about. So let's get on with that.
Will do, Your Honor.
Anything else we can do today?
I think, Your Honor, just I'll send over the order that you've requested.
Then let's get another date and let's get you guys out of here. How about Friday, March 19th at 11 o'clock? Is that going to work for everybody?
We will make it work, Your Honor.
That's fine, Your Honor.
Mr. Echoberry?
That's fine, Your Honor.
Okay, March 19th. By the time we are together, we should have our procedural issues done with the order to strike. We should have a better handle on where we are in terms of everybody having had an opportunity to review the disclosures from the other side. And it can maybe hopefully get some information as to what it is we're fighting about here. Because it's a factually complex situation, but not complicated from the perspective of the PIP claim. I mean, somebody's going to pay. It's either a comp matter or it's a
Right.
it's not that kind. Okay, I'm going to send out to you in order March 19th at 11 o'clock. I'll look forward, Mr. Brown, to your orders. Y'all have a good weekend and be safe.
Thank you, Your Honor.
We're
Thank
off.
you, Your Honor.
Have a good weekend.
We are on the record. This is file number 2016267. The case is entitled Calvary SPV versus Ophelia Angelo Lopez. By notice dated January 20, 2021, this matter is set for pretrial today, February 19 at 11 o'clock. It's now 11:33. Could I have your appearance, sir?
Good morning, Your Honor. Sean Bodwine, P71644 on behalf of the plaintiff.
Sir, you appear to be alone. We have no appearance from the defendant. She filed an answer but has not appeared. The court will therefore enter the default of the defendant. And I will look forward, sir, to your default judgment.
All right. Do you want that entered as a 7-day or just?
This is a some certain case.
Yes.
Okay, 7 day is fine.
Thank you.
Okay?
Yes.
Thank you, sir. Thank you for your patience.
No problem. Have a good day.
You too.